amazing. We had a podcast just a little while ago on the OSC didn't find in your favor and now what? And you can see by the date on this order on jurisdiction, January 17th, 2023, not too long ago, perfect example of the OSC telling my client, you have no case, you would never win, there would never be a finding of jurisdiction on this case. The administrative judge then gets a hold of it at the Merit Systems Protection Board, rules in my favor and says, hold on a second there. Yes, the guy would. And this is a really good example of the deficiencies of the Office of Special Counsel and how they take a surface level look at your case without really seeing what's underneath that case. So here's a client who will be confidential, and he works with an attaché in a Middle Eastern country, a rather dangerous one that I won't say. And there's a policy. And the policy is that DHS employees and their families would no longer be permitted to use Department of Homeland Security armored cars on an around-the-clock basis as needed for personal security as a result of a State Department vehicle use policy for this particular country. Meaning what had happened before was the State Department said, this country is a dangerous, dangerous place, and therefore any Department of Homeland Security personnel, employee that's stationed over there not only gets an armored car to prevent things like terrorist attacks and being fired on and so on. You not only get that armored car while you're at work, you actually get it even when you're not at work. You get it on weekends, you get it at night. And the State Department, for whatever reason, changed their policy and said, well, we've thought it over, and for whatever reason, we're ending this policy, and now you only get the armored vehicles at the time when you're working. So my client complains about that and says this is a danger, not just to me, but it's a danger to others. It's a danger to their families. He discusses what's happened in Afghanistan and other countries where people were killed unnecessarily, et cetera, et cetera. And then there's an issue of retaliation by DHS. They reduce this guy's valuation. They don't get him the transfer he wants, so on and so forth. Case goes to the U.S. Office of Special Counsel. They write the following. While you believe your disclosures regarding this policy constitute whistleblowing, we think it is unlikely the board would find your disclosures constituted a protected disclosure of information because it doesn't appear that there's any evidence of a violation of law, rule, regulation, gross mismanagement, gross waste of funds, abuse of authority, or a substantial and specific danger to public health or safety. Instead, it seems you disagreed with the interpretation of the laws, and that basically this is a disagreement about a policy. Sorry, guy, policy disagreements are not whistleblower disclosures. And it's almost like, look, guy, this is way, way ahead of your grade level. You can't be protesting or blowing the whistle on policies that you disagree with. Now, I knew when I took this case that's not the case because I remember many years ago, I remember about 6 or 7 years ago when I did the U.S. Senate committee hearing. I represented Michael Keegan as a national whistleblower. And the whistleblower before us who testified was the colonel who blew the whistle on the Bo Bergdahl trade. And that was a policy. That was President Obama made a decision, and the decision was we were going to trade to get Bo Bergdahl back for 5 of these terrorists, and he thought that was a bad trade, and he blew the whistle on that. And now he's in front of the U.S. Senate, in front of the Senate committee testifying about that. And the point is that just because something is a policy, that doesn't mean that it's immune from whistleblower disclosures. And this is what we argued in our brief. And we said, Judge, here's the thing. Maybe it was a policy issue that the person had a complaint about. But you know what? That doesn't matter. If it involves a specific danger and a substantial danger that he's raising, that counts. That is a disclosure. And the judge agrees with me, as you can see, and the judge says that basically what he did here is he points out that this is not an internal grievance, or I should say, this is not an individual grievance with management, which generally does not constitute a protected disclosure. This client, what he did, this federal employee, was he talked about the safety of other federal employees in this Middle Eastern country. He talked about the likelihood of the harm resulting from this danger, the imminence of the harm, the nature of the harm, and he goes through the whole thing, and you can see that the client absolutely does that. He explains this is a dangerous situation, and the court says, well, at this point, this is just the pleading stage of the case. This isn't the hearing, so the government will have the opportunity to cross-examine this man and try to find that he really didn't have a good faith belief, that he was just an employee who was disgruntled, so on and so forth, and there's nothing to see here. I think that's going to be very hard to cross-examine. I think this person had a legitimate complaint. If your family was stationed in a Middle Eastern country and there was an issue and there were rockets being fired at it, or there was some sort of the country known for terrorism or something like that, and the armored car could save many, many lives, as it did, let's say, during the Iraq War, certainly that is a whistleblower disclosure if it is a sincere belief. So this is a perfect example of the point that was made in the last podcast, that just because you get a finding from the Office of Special Counsel, that doesn't mean that that finding is correct. It doesn't mean that it has any precedential value, and you have the opportunity to still maintain your whistleblower case and bring it now to the Merit Systems Protection Board. Remember, you have 65 days to do that from the day of the letter from the OSC, not the day that you get it. Call our office. We can help. We invite you to subscribe to this YouTube channel, and also we invite you to send any comments you may have if you want to hear future podcasts on some issue that's really important to you that we haven't done yet. Let us know that, and we can do that.